If you're headed into a deposition in California, you might feel a little overwhelmed by all the legal lingo. Depositions can be intimidating, especially if it's your first time or you're not familiar with the process. The pressure of answering questions under oath with attorneys on both sides can make anyone nervous. It's much worse if you are not represented and you have to object to the questions and then answer them. This cheat sheet can give you a basic understanding. Today, I'm breaking down the basics of making objections in your deposition so you don't accidentally waive your rights. Knowing when and how to object can make a huge difference in protecting yourself and your case. Consider this your cheat sheet to California Deposition Objections. Keep it handy, and you'll feel more confident and prepared when the time comes. First, why do objections even matter? Objections aren't just for show, they're a critical part of the legal process. They help make sure the deposition stays fair and that your rights are protected. If you don't object to certain questions or refuse to answer when you should, you could lose or waive important legal protections. So here's what you need to know. Understanding the basics can help you avoid costly mistakes and keep your case on track. Let's start with the most common objections to the form of questions. The way a question is asked can be just as important as the answer you give. If a question is compound, meaning it asks two things at once, you need to object. Compound questions can confuse the record and make your answers unclear. If it's vague or ambiguous or sounds argumentative, don't be afraid to speak up. You have the right to ask for clarification or to object, and in rare circumstances like protecting privileges or privacies, refuse to answer. And if it calls for speculation, like asking you to guess or speculate what someone else was thinking, say objection, calls for speculation, lack of personal knowledge. Next up, privilege. Remember, questions should seek non-privileged facts. You're only required to answer what you know, not what you assume. Some things are just off limits. Privileged information and financial, medical, and tax return privacies are subject to protections by law, and you don't have to disclose it during a deposition unless it supports your claims or defenses, and/or by mutual stipulation or court order. Careful here. If you refuse to answer, which you must do to protect the privilege, opposing counsel may bring a motion to compel with sanctions, but sometimes you should refuse and then ask counsel to stipulate to limited disclosure and use of the protected information. You almost always have to refuse to answer anything covered by attorney-client communications or your attorney's work product, like their mental impressions, strategies, or legal opinions. These protections are there to ensure you can speak openly with your lawyer. Never quote your lawyer or disclose private discussions, or you will waive those rights. This also covers medical, spousal, and Fifth Amendment privileges. For example, you can't be forced to reveal private conversations with your doctor, spouse, or to incriminate yourself. If you're unsure, just say objection, privilege, and if counsel threatens to bring a motion, offer to stipulate to limited disclosure and limited use. It's better to pause and offer to come to an agreement than to accidentally give up protected information. If you feel a question is harassing, oppressive, or just not relevant, namely, not calculated to lead to admissible evidence, speak up. The deposition process should be respectful and focused on the facts and issues at hand. Same goes for questions that ask for an improper opinion or conclusion, like legal or medical opinions you're not qualified to give. You're not expected to be an expert unless you actually are an expert witness. If so, call attorney Rydstrom for representation. Another big one. If a question misstates your previous testimony or evidence, or if it's something you've already answered, don't be afraid to object. It's important to keep the record accurate and avoid confusion. Do not let the attorney put words in your mouth. And if the other side is fishing for protected work product or didn't follow proper deposition procedures, that's also objectionable. Always be alert to tactics that might undermine your rights. Remember, attorneys aren't allowed to intimidate witnesses or make speaking objections. They should keep it short and to the point. Professionalism is key, and the rules are there to protect everyone involved. And if someone asks you to state every single law or fact supporting your case, Rifkind v. Superior Court says you don't have to answer. Don't let anyone pressure you into giving more than you're required. This isn't a complete list, but it's a solid starting point. Every case is different, and there may be unique objections that apply to your situation. The best move? Hire an attorney to protect your rights, because if you don't, you could accidentally give them up. An experienced lawyer can spot issues you might miss and make sure you're fully protected. If you're in California and need guidance, call attorney Rich Rydstrom at 949-678-2218. Having a knowledgeable advocate on your side can make all the difference. Stay prepared and don't let legal jargon trip you up. With the right information and support, you can handle your deposition with confidence and protect your interests every step of the way.